Oh la 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 bam bam. Oh la 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 bam bam. Oh la 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 bam bam. Oh la 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 big it up. Oh la 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 big it up. Oh la 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 bam bam. Bir ba 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 bir ba bir de. Bir ba 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 bir ba bir de. Bir ba 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 bir ba ba bir ba bir de. Bir ba ba ba.
Hello, everyone. Welcome to Home and Away Jamaica, where we connect Jamaica with the diaspora. Today, we have co-host Paulette Price. Welcome, Paulette. Glad to have you next to me. And we also have two very important persons. Shanice Williams Headlam, Director, Rent Services Unit, and Mr. Leighton Baker, Rent Assessment Officer, both from the Rent Assessment Board of Jamaica. Welcome to you both, Ms. Williams Headlam and Mr. Baker.
Thank you. Thanks for
having us. Yeah.
We're very glad to have you today. On our program, we generally speak about issues that not just affect Jamaicans in Jamaica, but Jamaicans living abroad and those Jamaicans who are connected to home. Most times, this connection is through their investment in real estate. And the issue of landlord and tenancy is one that very frequently comes up in our discussions. Many persons abroad own property in Jamaica, and in their absence, the property is tenanted. As we all know, tenants and landlords can have disputes. And so the question is, how are these disputes resolved? Many persons may have written leases, many persons may not have leases. So we want you to tell us the mandate of the Rent Assessment Board and how you function as part of the Rent Restriction Act, which effectively guides and provides the provisions that sets the legal framework within the rent and landlord environment.
Okay, so the Rent Assessment Board basically deals with landlord and tenant related matters. So any dispute that a landlord is having with his tenant or a tenant having with his landlord, they can take it to the Rent Assessment Board, and we mediate in those matters. Also, we have judicial hearings twice per month, sometimes 3 times per month, depending on our caseload, where landlords can sue their tenants for arrears of rent, and also tenants can sue their landlords for security deposits, and if the landlord increases the rent above 7.5%.
You just mentioned the annual increase that's capped and limited to 7.5%, and this is something that comes up from time to time. There are some persons who are unaware of this 7.5% limit. There are some persons who feel that, particularly in periods of high inflation, 7.5% is inadequate to cover any increase in inflation and properly provide an adjustment for the rental income. Is this one of the most pressing complaints that you come across? And maybe share with us some of the other issues that you find you must contend with between both landlords and tenants.
The Rent Restriction Act gives the landlord 7.5% increase annually. If they desire to have more than the 7.5%, they have to come to us and seek our approval. Now, if a landlord has made improvements to their property, they might spend to upgrade, might add a bathroom or a kitchen or whatever they needs be.
Yeah.
They can come to us and we will take into consideration the fact that the premises are being improved and see how much more above the 7.5% that we can do.
So that's not rigid then.
No.
How do you deal with, we have a lot of US dollar rentals in Jamaica. How do you manage that issue? Is this something that is brought to your attention for resolution?
Yes, we have some concerns. The US dollars, our law speaks to Jamaican dollars, right? If somebody agrees to take a premises for US dollars, they must take into consideration that the Act allows for 7.5% increase only. Now, if you agree to take a premises in US dollars and have to purchase the dollars locally, you know, there's a possibility that every month you might be paying more for that, you know. So we would deem that as an increase above the 7.5%, you know. But as it is now, we have no guidelines where US dollars is concerned. But it's a concern to us, really, you know.
So effectively what you're saying then is if someone's paying rent in US dollars, let's say $1,000 a month, and the US dollar at a particular time is 130 Jamaican dollars to one US dollar. And within a year, the Jamaican dollar devalues, let's say, to 150. And instead of purchasing, you know, 150,000, using 130,000 Jamaican dollars to make that purchase, and you're now using 150,000 Jamaican dollars to make that purchase, you'd have exceeded the 7.5% cap within that given period. Well, thanks for that. And I think that's something that can inform all viewers.
I'd like to ask a question. You mentioned, Mr. Baker, that if a landlord upgrades the apartment, for example, you know, puts in a new toilet or something, that may be some sort of justification to go above the 7.5%. But most people would say it is the landlord's duty to keep their property maintained and upgraded. Do you get that kind of response at all?
Yes, but maintenance is not. Well, before I go there, let me get back to the US dollars. That $1,000 US, right? That is being charged when the time comes for a 7.5% increase. I don't know about 7.5% increase of the $1,000 US. I know of 7.5% increase of the Jamaican dollar. So we also need to take that into consideration.
Yeah, thanks for that clarification.
Right. Back to the question of maintenance. Maintenance is not considered a part of. You must have to spend some substantial amount of money, right, for us to see somebody maintaining a property. That's not a part of the additional increase that you can get. As I said before, it's for improvement on the property, as well as taxes, rates and taxes increasing.
So, for example, if a landlord builds a fence around his property to protect the property, and adds a grill at the windows and grill at the door and so on, that is considered as being improving the property. So those are things that we would take into consideration.
As well as I did mention the addition of a bathroom or a kitchen or a veranda.
Improving the property.
That type of improvement is taken into consideration.
On the matter of security deposit, what are some of the issues you have in relation to security deposits? Because I know as well this is a commonly disputed area.
Right. So some persons do not understand what a security deposit is. So, for example, a tenant will come to us and say, my landlord does not want to return my deposit, or I'm going to live out my deposit. First, what we usually do is explain to them what a deposit is and how they can get it back when they leave. So a security deposit really is some sort of insurance for the landlord. So in the event that the tenant leaves with bills outstanding at the property, or if he or she damages some part of the property, the landlord can use that deposit to repair or pay the bills. And if there is money left from after doing the repairs and paying the bills, that should be returned to the tenant. But what we usually do is inform the tenant that it is not automatic that you'll get it back. Because some tenants, they leave without giving the landlord a 30 days notice that they're going to leave, but they expect to get it back. So they tell the tenant, the landlord, I'm leaving your property tomorrow and I want my deposit when I'm leaving. In that case, they couldn't get it back because you would have to give the landlord a 30 days notice for them to get it back. You have anything to add?
Not at this time.
Okay.
Thanks for that. And so what I understand you're saying is there are tenants who, for some reason, may say, you know, I'm in month 10 of a 12-month lease. My landlord has 2 months deposit left for me, so I'm going to allow them, or I'm going to be at the liberty of having them apply that remaining 2 months and have it deducted from the deposit. But what you're explaining is there is still an obligation for that deposit to be kept whole at the end of the tenancy, so that if for any reason the landlord needs to make a deduction, either for damage to the premises or the improper notice period being observed,
Right.
then that reserve needs to be kept intact.
Yes. So we usually inform the tenants that the deposit is not rent. So if you want to leave it out, it is best to talk with the landlord first.
So that would have to be by agreement.
Right. Yes.
Right.
And also, if the landlord is deducting anything from the deposit, you should put it in writing to the tenant that this is what I'm charging for, the amount, and so forth. And if the tenant is not in agreement, they can take it to us for us to scrutinize to see what is it in there that they are responsible for and what is not.
Can a tenant demand interest on deposit that's held by a landlord?
No.
Okay, that's a question I come across frequently.
Oh. I guess because the access, the deposit, they say something about interest bearing account somewhere.
Possibly, you know.
So they.
And many times it comes from persons who've lived abroad,
Oh.
where the laws may be a little different.
Oh.
I have a question I'd like to ask. You talked about these hearings that you have sometimes twice a month, sometimes 3 times a month. Does the landlord have to have registered with you as a landlord, or can somebody who's not registered come to you with a issue and then you will deal with it?
It is a requirement by law, I say, that all rented premises should be registered at the board. All right, it is a requirement. So there are some persons out there who have not done so. But whenever we find that out, we usually ask them to comply, and they usually do. But whether or not they have registered, they still fall within the purview of the Rent Restriction Act. All right. Because whether or not you sign an agreement, there are some things that kicked in, like the tenants and landlords covenants, right? Which would govern all rented premises, right? So yes, whether or not you're registered, you can come and use the facilities of the rent board.
To use your services. Can I ask you, what do you have to do to register, and how many people are registered? And do you see the number of people, is there an increase? What are the benefits of registering? Because obviously I'm in real estate and I deal with a lot of people who have properties to rent, but I've never heard any of them say that they are registered. So maybe it's something that, you know, we in our industry could encourage people to do, but people will always want to know what are the benefits.
I don't look at it as a benefit per se, you know. I look at it as a requirement by law.
Yes.
Right? The law requires you to do this. But that same 7.5% that we talk about, it is tied to you registering. Right? So if you're not registered, you should not be increasing your rent by 7.5%.
Mm-hmm.
Ah, that's good to know. Okay.
So like I said before, whenever we find out that these premises are not registered, we tend not to use the in the first instance the law that the section of the law that requires us to take action. We just ask them to comply, and they usually do. Right, and then we move on from there.
And I must add too that the registration cost is $20. So usually they will comply with
Just $20.
20 Jamaican.
20 Jamaican dollars?
Yes.
Wow.
It will be increased soon, so
All right.
we're encouraging
Okay.
people out there to apply.
Actually, I should use this video to let that this figure was set from 1983.
Right.
In 1983, it meant something.
Yes. Yeah.
The Rent Restriction Act has not been amended since.
I know. Yeah, I know.
So it is in the process of being amended. So pretty soon that increase will be more.
Okay. Hopefully it's not $200 or something like that, but it would be good to keep it affordable. Okay, so what do they need to do to register? What is the process, and how long does it take? And how can is there a register that we can check if people are actually registered? You know, like a tenant can go and check on your website that these tenants are registered. Sorry, these landlords are registered.
No, nothing on the website, but they can find that out by calling us.
Just by calling, right? Okay. So the process is what? Just filling out a form?
So there's a form. We have a website that persons can go to. There's just Google Rent Assessment Board, Jamaica.
Yes.
And you will find our website where you can apply online. Just click on termination of the standard rent and fill out that application form, and it will come directly to us via email. But in terms of paying for the application, they would have to send somebody. If they're not in Jamaica, they would have to send somebody to pay the money for them here at the Ministry of Economic Growth and Job Creation.
Or if they are not at nearest point, because this rent assessment is the only board in Jamaica. We deal with the entire island. But we have Ministry of Housing offices in 4 regions that they can also visit to fill out this application form and pay the fees there.
Right. Those are St. Anne's Bay, Westmoreland, Montego Bay, and Clarendon. Those are the housing offices.
And the Westmoreland, it is located in Sablama.
All right. So would you consider at some point doing this online? Because, you know, we need to do things online now.
Yes.
Okay. In the near future, let's say.
In the near future, yes.
All right.
Please do.
Yes.
Right.
All right.
We've been speaking so far about residential tenancies.
Yes.
The law makes a distinction, and in particular with the requirement for 7.5% increase. Can you share with our viewers and listeners what that distinction is and how exactly does it work if you're a commercial landlord, what are your expectations? And similarly, if you're a commercial tenant.
Okay. All, as I said before, all renting premises would fall within the jurisdiction of the Rent Restriction Act. All right. But the law allows for the owners of commercial properties to apply to us for what is called an exemption from the provisions of the Rent Act. It's the same $20 to do so. All right. There are 4 grounds on the application form that suits any property in Jamaica. Right? They just tick off the one that best suits their property. Grounds like the premises exceed 1,000 square feet and it's for the time being designed to be used primarily as a warehouse. That's one. The other one is that the building was constructed after 31st of August 1982. The other one is that the premises could have been rented, if it was constructed before 1980, it could have been rented for $6 or more per square foot. In urban and rural, it's $4 or more per square foot. Now remember, these figures were set from 1983, but you would apply. And then there's another one, if the premises was sold between 1980 and 1982, right? You can apply for that exemption. If the exemption is granted, then naturally you're exempted from the provisions of the Act, right? You set your own rental, you set your own increases. Well, basically, you're free to put whatever it is you want to put in your contract, right? As long as the tenant and yourself agree on it. As long as the tenant sign to it, well, you're good to go. But a number of persons, there's an issue where some landlords and attorneys believe that an exemption allows you to put out a tenant, lock out a tenant forcefully.
Section 26 doesn't apply.
So you
No, 27.
27 doesn't apply, yes.
Right. So from our point of view, you still have to serve the tenant a notice and take them to court for recovery of possession.
Can you speak, since we're on that point, to the 2 sections within the Act that speak to notice for residential and commercial tenants?
The years ago, it used to be 1 year for commercial properties, right? And at least 30 days for residents. The 30-day notice for residents still stand, but with the exemption, it allows you to grant any amount of notices you desire. It could be a month, 2 months, 3 months, whatever it is, right? But that part of the Act, a case was settled once using a month notice. The premises was not exempt at the time, and using a month notice, and it reached the Supreme Court. The court made an order, and it was a precedent was set where whether or not you're exempt, you can give a month notice
On the commercial tenancies.
but you still have to go.
The section also speaks to stating specific reasons. Do you find persons coming to you to make inquiries as to whether notices issued are valid under the Act?
Yes. Even yesterday, I had one client who came in with her notice, and she was quick to point out to me that this is not a valid notice. So I said, how do you know? She said, I'm just coming here now to just make sure this is so. So she showed me that this is not even her address. And the name of the attorney who would have signed the letter, it seems like a fictitious attorney and so on. And there are a number of inconsistencies in that notice. And when I read it, I told her, yes, it is invalid for true. So I had to stamp the notice and say it was invalid. So we have a number of persons who come with these notices to say that it is not what it is appearing to be.
So you have a process of validating these notices?
Yes, we do. So we have to, the notice has to have the address of the premises. It has to have reasons for the notice. It has to have the date when the tenant is supposed to leave the premises. It has to have who is serving the notice, the address of the premises, and the date of the service of the notice.
And I should also point out to that for landlords who give a reason that the rent is in arrears, if that's the only reason on the notice, and the tenant pays the rent, that notice is no longer valid.
Right.
Right. So
the lease continues in force.
Yes.
Right. So if a landlord really wants to have the tenant leave the premises, they would put two reasons on that notice: arrears of rent or some other reason.
Right.
What is stipulated in the act, whether the premises.
Yes, right.
What is in the act? Because we have sometimes persons are not 100% certain how to write a proper notice, so they will put it as we're not getting along.
Oh.
And that is not a valid reason for giving a notice. It has to be reasons within the Rent Restriction Act, which are for arrears of rent, if you want the premises for somebody dependent on you as a landlord, or if it is that you want your family member to occupy the premises.
Repairs,
major repairs, and so on. So those are some of the reasons that can be. You can't even put if you want to sell a property right now. No. So
also a contentious issue.
Right. So people usually put that too, that they want to sell their property and they want the tenants out. But if you carry that to court, it can't stand because it is not in the Rent Restriction Act as yet.
Is there, to your knowledge, any move afoot to amend? I know there have been discussions about amending the Rent Restriction Act. Can you say exactly where we are, where the draft legislation has been put in place?
There is a draft, yes, and
I like the way you both look at each other.
But, you know.
Now, I was just trying to figure whether it's in its 8th draft or
beyond.
Yeah.
All right.
But this is being worked on.
It is with the city.
Yes. We asked that question because we know that it was so long ago that it was updated, and I did my real estate course in 2009, and I have heard, oh, it's going to be updated, That's 11 years ago. So, you know, when we asked the question, we're wondering, is it soon? Is it, you know, is it a draft, or is it going to be, you know, where is it?
It's with the cities.
It just takes too long, is what we're saying.
Right. Yes. That is true.
Yeah. I have a question. Most people think that the Act protects the tenant more than it protects the landlord, and I would love you to speak to that. And the reason why I brought it up is because, yes, I know you have bad landlords, but you also have some really terrible tenants.
Yes.
I think I read somewhere that there is supposed to be a bad tenants registry held somewhere, and I don't know if that's just a rumor or if that's real, or do you think it's a good idea? What can we do to make it more balanced?
It's a good idea, but it's not with us. You know.
Sorry, it is what?
It's not with us.
You
know, it's a good idea to have that type of registry for both landlords and tenants. You know.
It was a suggestion made when we had our consultations.
Right.
Regarding the amendment of the Act, persons had suggested having a registry for the recidivists, the landlords who constantly mistreat their tenants, and the tenants who constantly
break all the rules.
Break all the rules at the premises that they're in. So, but we're not sure if that will be included in the Rent Restriction Act in the final.
Right.
However, you were saying that tenants the act protects tenants.
There's a
That's
perception.
what most people feel. Yes. Yes. The perception. Yes.
And what's the history of that? So the Rent Assessment Board was established in 1944,
Yes.
right? And in that time, you had landlords who were rich and
Yeah.
they owned everything, and the tenants were mistreated in most
Yes.
occasions. They were mistreated and treated really poorly. Now, when the act was amended in 1983, there was a drive then, I would say, to kind of balance it a bit,
Yeah.
to let the tenants have some sort of comfort then in the
Yes.
premises that they would rent. But then it would appear to others that the law is protecting them alone.
Yes.
It really was trying to stop some of the mistreatment
Yeah.
of the tenants.
And then,
Yeah.
and then over time, things have changed, a bit. But the law the law is always behind with changes. So the I'm searching for a word, but I always say to landlords, right, that there's always a solution to the problem you're having. The only thing is that some landlord takes too long to act upon these things that are in place, right? You're having problem with your tenant owe rent. I want to know why some landlords wait until the rent reach, right, X amount, $1 million, under $1 million also. No, we have over $1 million now, but I won't go for an under $1 million. Let's say 500,000 when your rent is only $10,000 or $20,000. From the very first rent that is owed, after 30 days, you go to the court and sue. You don't wait until you're having difficulty with your tenant. They harass you. Well, harassment works both ways, and you put up with that for months. When all you have to do, when that harassment starts from your tenant, you serve a month notice, right? 1 month notice, and then they might serve another one. They might serve up to 3 or 4 different notices. Why that? The law requires you to serve a 30-day notice, and then you take the matter to court. The court, in its wisdom, will decide on when the tenant is expected to leave the premises. If they don't leave, then you go ahead and get the bailiff and you put them out. But some landlords sit with the problem. It's their problem. It's their premises. They want to do whatever action to have the tenant out. When it's not so, you go to court and let the court deal with it.
One of the areas Mr. Baker and Mrs. Williams-Headlam, we see creating, I think, a lot of this anxiety with the landlord-tenant relationship, and Paulette, I know, would experience it as a realtor, is when property is being sold. And so someone may give notice that for some reason, or whatever the reason is, a premises needs to be reoccupied by the landlord. And behind this is a sale. The sale takes place, there's a closing, and the tenant remains in possession. And then it's at that point that the proper notice is being served. And then you have the dilemma where you have a new purchaser, sometimes paying mortgage on property that they can't occupy. And then you have a tenant who remains in possession and can remain until an order of the court is granted.
Yes. We were speaking about that same scenario where a landlord had purchased, a homeowner had purchased the house, and she inherited tenants, and they were not planning to leave and not planning to pay the rent at all. But what we usually tell persons is that they would have to serve a notice on the tenant the original owner, original landlord would have to serve a notice on the tenant for them to leave. In the event that that fails and the tenant is still there and the deal goes ahead and the new owner is there, then the new owner would have to take them to court under Section 89 of the Parish Court Act, right, for them to recover their property from that tenant.
And then any claim for rent would involve a separate claim, a separate suit.
Yes, but I think they can.
It can go together.
Go together. Okay.
So I have another question. Does the Rent Restriction Act take into consideration the different types of rental agreements? So you may have somebody who is living as a tenant within your house, somebody who's living as a short-term renter in another property, as well as somebody who's a long-term renter who has their contract renewed every year. Does the Rent Restriction Act is it able to deal with those different types of rental agreements?
Yes, the only thing we don't deal with, because it is exempt. That's one of two residents that are exempt.
I didn't hear which one was exempt.
That's one of two. One is that once you're operating a boarding facility,
right,
that don't fall within the
okay.
And boarding must include at least one meal to the tenant, right, to make it a boarding, right. There are other premises which are automatically exempt, but I'll just go to another form of resident. These are residents that are owned by the Minister of Housing. Minister of Housing, right? Those are exempt. Other categories, I go back to the commercial, which are automatically exempt. These are hotels and resort cottages, factories owned by Factories Corporation, airports and aerodromes, and and public buildings. Those are automatically exempt. So the landlords really don't have to apply, but we find a lot of them do. They love to have their certificates on hand. So they do apply.
Well, thank you both. We've, I think, covered a lot of the contentious issues, and you've clarified a lot for us. We really appreciate you taking time out of your busy schedule. I know also COVID has imposed a lot of challenges, particularly on the work environment. So we want to thank you for spending the time with us.
We just want to give before you go, the address of the rent board and the telephone.
Yes.
Okay, so we're located at 25 Dominica Drive. That's in New Kingston, for persons who are not aware. We're at the Towers on the 3rd floor. And our telephone numbers are 906-1765 or 906-4100 or 906-7072. And you can email us at rentassessmentboard.gov.jm.
No, sorry, Rent Assessment Board
at megjc.gov.jm. Sorry.
All right.
Well, thank you very much, Mr. Baker, Mrs. Williams Headlam. It was a pleasure having you. Thanks again on behalf of all of us from Home and Away Jamaica TV. And I'm sure when we have a new act, we'll have you come on and share some of those amendments with us. Thanks.
Definitely. And I'm hoping that you probably work with us as well, realtors, just so that we can tell you the kind of things that we experience. And if that could help with the act, that would be good too.
We also do presentations here.
Excellent.
So And if you
Yeah, great.
can make your request.
Yeah, that's fabulous. Thank you both very much for your time.
All right, take care.
Thanks
Yeah.
again. Enjoy
Yeah.
your day.
You
And
too.
continue to stay safe.
All right, you do. All right.
Yeah.
Bye-bye.
Bye-bye.
Oh la 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 la, bam bam. Oh la 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 la.